Ready, start. The appellant herein, a workman, was engaged on daily wages in the year 1992, full stop. His services were terminated in the year 1999 on the ground that he had been involved in a criminal case, full stop. It is the conceded position that the criminal case has ended in his acquittal, full stop. The appellant also raised an industrial dispute alleging violation of Section 25 bracket F of the Industrial Disputes Act, 1947, full stop. The matter was referred to the Labour Court, which held in favor of the appellant, directing his reinstatement with 50% back wages, full stop. The state of Haryana challenged the order of the Labour Court exclusively on the plea that the award of back wages was not justified, full stop. The learned single judge, however, allowed the writ petitioner filed by the state in toto and set aside the award of the lab court and instead awarded a compensation of rupees 60,000 to the appellant, full stop. The matter was thereafter taken before the later patent bench, and it was argued that the challenge in the writ petition had been limited to the award of back wages, and the judgment of the single bench setting aside the award in toto was beyond the prayer, full stop. The division bench noticed this argument but nevertheless went on to hold that as the issue with regard to the status of a daily wage employee was covered against the appellant by a string of judgments of this court, the technicality with regard to the prayer in the writ petition would not stand in the way of the High Court making an order setting aside the award of the Labour Court, full stop. The division bench, accordingly, affirmed the order of the learned single judge, full stop. The appellant workman is here before us in appeal, full stop. Before us today, the learned counsel for the appellant has argued that in the writ petition filed by the respondent challenging the award of the Labour Court, the only plea was against the grant of back wages and nothing more, full stop. In support of this submission, the learned counsel has drawn our attention to the writ petition which has been appended with the paper book, full stop. We find that the assertion of the learned counsel is correct, full stop. We are, therefore, of the opinion that the order of the single judge as well as of the division bench was well beyond the scope of the prayers in the writ petition, full stop. If the state felt aggrieved by the award of the Labour Court in toto, there was no impediment in its way to challenge it in its entirety, full stop. We feel that a party must be held to be bound by its pleadings, a prayer clause cannot be construed or dubbed as technicality, full stop. We are, therefore, of the opinion that the appeal deserves to succeed, full stop. We, accordingly, allow the appeal and set aside the orders of the single judge as well as the division bench and restore the order of the Labour Court to the extent of reinstatement, full stop. We are also told by the learned counsel for the appellant that the appellant had in fact been reinstated, but after the order of the division bench, his services had again been terminated in December, 2009, full stop. We, accordingly, direct that the back wages envisaged would be payable only from January 2010 onwards. Fill his retirement void this order, full stop. This appeal by grant of special leave is directed against the judgment and order passed dated September 13, 2007 passed by the High Court of Andhra Pradesh in Criminal Appeal number 1009 of 2005, full stop. The High Court allowed the government appeal, reversed the judgment of acquittal passed by the trial court, found the appellant guilty of the charge of killing his wife Lakshmi Kumari by giving her cyanide in cold drink and, accordingly, convicted him under Section 8 of 302 of the Penal Code and sentenced him to rigorous imprisonment for life and a fine of rupees 1000, and in default of payment of fine, simple imprisonment for 3 months. Full stop. The basic facts of the case, which are admitted or are at any rate undeniable, need to be stated in the sequence in which those facts were unfolded. Full stop. The appellant and Lakshmi Kumari got married on April 30, 2000. Full stop. After marriage, they came to live in a rented house at Hyderabad. Full stop. The appellant and his wife lived on the first floor, and the remaining portion of the house was occupied by its owner. Full stop. The appellant had a graduate degree in engineering and a diploma in computer. Full stop. He worked as a faculty member in Harika Information, situated at Hyderabad, and he also gave coaching to students in another computer center. Full stop. He was earning a salary of rupees 20,000 per month, on September 2, 2000. Full stop. Stop.